Hi, everyone, and welcome to today's webinar, Local Flavored Litigation, What's the Scoop? My name is Jima Fambula, and I'm a staff attorney at the Public Health Law Center. Thank you for joining us for an important discussion, the lawsuits brought by the tobacco industry against local governments across the country, and what those lawsuits mean for communities working to advance public health and equity. I'm joined today by my colleagues at the Public Health Law Center, staff attorneys Kira Hill and Jamie Long, and lead senior staff attorney Natasha Phelps. We all work on the commercial tobacco team at the Public Health Law Center. But first, if you are not familiar with the Public Health Law Center, we are a nonprofit legal center housed at the Mitchell Hamlin School of Law in St. Paul, Minnesota, on the traditional, ancestral, and contemporary homelands of the Dakota people. Our center consists of attorneys, public policies, planners, communication staff, and an amazing administrative team. We work to advance public health through the power of law. We have two main policy teams, one that focuses on commercial tobacco regulation, that's the team that I'm on, and one that focuses on healthy and cultural competent eating and physical activity. Our commercial tobacco control team has attorneys, policy analysts, and support staff to provide free legal technical assistance to any of you that have joined our webinar today, are interested, or currently working on commercial tobacco issues. We work together regularly, but have four separate teams. One that works on California commercial tobacco control, one focused on Minnesota, a national team, as well as a group that specializes in FDA issues. Here's everyone. We do offer free legal technical assistance to communities, advocates, health departments, and others working on commercial tobacco control around the United States in several ways. We do this through legal research, policy development, implementation and defense, as well as through a wealth of publications and resources available on our website at www.publichealthlawcenter.org. We also provide presentations, webinars, and trainings such as this one. However, the Public Health Law Center does not represent clients, and we do not lobby. We provide legal technical assistance related to issues at various levels of government, from tribal law to federal, state, and local law as well. The Public Health Law Center believes that everyone deserves to be healthy. At PHLC, we believe that effective policy is equitable policy, especially when it comes to public health, and especially when it comes to commercial tobacco policy. Health equity is at the core of our work. Our goal is policy that improves public health. This means that we must consider equity issues within the umbrella of health as well as outside of health. We consider the social determinants of health, adverse childhood experiences, and inequity in general. We consider it our responsibility to use our legal knowledge to bring justice to public health, as well as support our partners in reducing health disparities. When all people are healthier, the communities they live in are happier, safer, and more vibrant places. To us, health equity means that everyone has access to the particularized resources they need to improve their own health and maintain healthy outcomes, to identify systemic racism, ableism, and other inequities that act as a barrier to health. This requires moving beyond a one-size-fits-all approach, as well as overcoming and removing barriers that infringe on fairness, human rights, and environmental justice. We believe that for policy to be effective, it must be equitable. This is especially important in tobacco. And what are we talking about? When it comes to commercial tobacco, we cannot talk about inequity without talking about flavored tobacco. We know that the tobacco industry has historically and aggressively marketed flavored tobacco products, and particularly menthol flavored products and cheap flavored cigars, to young people and Black Americans, especially in urban and low socioeconomic neighborhoods. We also know that the commercial tobacco is a major contributor to 3 leading causes of death, which, by the way, are exacerbated by COVID-19, which also disproportionately impacts Black and Brown communities. Black Americans are more likely to die from lung cancers than smokers who identify as another race or identity. So the inequity is coming and resulting in hardship, health harms, and death for Black Americans all around when it comes to flavored tobacco. This is why the commercial tobacco team has prioritized its flavor work, especially its work on menthol flavored cigarettes for several years. So today's agenda. And with that in mind, we are going to talk about the lawsuits that the tobacco industry has brought against governments that have tried to protect public health from the harms of commercial tobacco with flavored tobacco sales regulations. I'll briefly summarize the legislation and legislation related to flavored tobacco prior to this year. Then I'll turn it to Jamie and Kira for an overview of the active litigation across the country. And finally, Natasha will ground us in some context lessons and messaging from communities considering that are currently working on flavored tobacco regulation. If you have any questions, please enter them into the Q&A box, chat box, and we will try to get them at the end. All right. There has been regulation of flavored tobacco product sales for over 10 years with the intention of protecting public health. In 2009, the Tobacco Control Act prohibited all flavors in cigarettes but the menthol flavor. Instead, the FDA was charged with looking into and taking appropriate action on menthol. The FDA has not acted on menthol despite overwhelming evidence to do so. The exclusion of menthol from the list of flavors prohibited in cigarettes has resulted in death and addiction that is devastating. Despite its major flaw, the Tobacco Control Act flavored cigarette prohibition has been effective. A recent study found the federal flavor ban led to a 43% decline in smoking among youth ages 12 to 17 and a 27% decline among young adults ages 18 to 25. Since the Tobacco Control Act was passed, the tobacco industry has sued multiple jurisdictions, as seen here, that have passed variations of prohibitions on the sale of flavored tobacco products, arguing that the sale regulations constituted a product standard and were thus preempted by federal law, among other arguments. All of the cities were successful in defending their flavored tobacco regulations. The courts found that they were not preempted from prohibiting the sale of flavored tobacco products. However, these cities did not prohibit the sale of all flavored tobacco products everywhere in their jurisdictions. Unlike the trend we see across the country now, which started with Yolo County and San Francisco, California. Many jurisdictions across the country have passed full bans on the sale of all flavored tobacco products. Until recently, the tobacco industry hadn't sued, and then they did against LA County. And now I'll turn it over to Jamie to give us more details about this litigation.
Thanks so much, Jima. And so that's a great introduction to the lawsuits that we've been seeing in California. And we know that a lot of them have been focused on preemption, so I think it's worth just having a quick overview of preemption. Jima touched on this as well, but preemption is a basic concept that the laws of a lower level of government must yield to a higher level of government if there's a conflict. And there are two basic types. There's express preemption, which is where a higher level of government has explicitly said that a lower level of government can't act, and implied preemption. There are two types of implied preemption. Field preemption, which is where a higher level of government has been so active in an area as to thoroughly occupy the field. So one example might be federal immigration law, where courts have found that states can't get involved in that area since there has been such a broad array of laws passed in that area. And then conflict preemption, of which there are two types: impossibility, which is pretty self-explanatory. If you can't comply with both a higher level of government and a lower level of government at the same time, that might be a conflict. And obstacle preemption, which is where a lower level of government's law stands as an obstacle to achieving the goal of a higher level of government. So these are the types of considerations that are being put forward against some of the flavored tobacco policies. And in California, there have been 6 cases so far that have been brought under preemption claims, all within the last year. And you can see that they've been targeting 3 different local ordinances, as well as the state law SB 793, which we'll discuss. They've all brought claims under express preemption under the Tobacco Control Act, as well as implied preemption. And we'll walk through each of these cases a little bit. So first, it's helpful to just set the context that excitingly this summer, California legislature passed overwhelmingly SB 793, that's the bill title for the law that created a nearly comprehensive ban on flavored tobacco products. They're only the second state to do so after Massachusetts. They had 3 exemptions for hookah, premium cigars, and pipe tobacco. But the big debate was over whether to include menthol, and in a big victory for public health and for equity, the state did move forward with including menthol cigarettes in the prohibition and menthol flavors as well. The tobacco industry leapt into action as no surprise, and they initiated a referendum effort under California's constitution. Voters can challenge laws and put them to a vote of the people under a referendum. This effort, though, they have to disclose who their funders are, and no surprise, it's R.J. Reynolds and Philip Morris behind the referendum effort. This is just a brief timeline of where we're at in the process. The petitioners are currently in the process of gathering the required signatures. They have until November 30th to do that. And if they do gather the required signatures, then it will be going on the ballot in November 2022, which would mean the law would be put on hold until then. If they fail to get the required number of signatures, then the law will go into effect on January 1st. But in the meantime, the industry has also sued in court, and so they sued Javier Becerra, the state's attorney general. They also included the San Diego County district attorney in their lawsuit. This might have been an attempt to get to a specific venue because there are some cases pending in San Diego that we'll also talk about. And they brought both an express preemption claim and implied preemption, similar to the ones that Jima discussed previously. They also brought a dormant commerce clause claim, arguing that SB 793 is regulating manufacturing that happens outside of California's borders exclusively, and that would be prohibited under the Commerce Clause of the Constitution. They have filed a preliminary injunction motion asking that SB 793 be put on hold pending the outcome of the case, but interestingly, only on the express and implied preemption, not on the dormant commerce clause claim. And so that case is scheduled for argument in the Southern District in California on December 10th. San Diego County has also been targeted with 2 lawsuits, one by retailers and one by manufacturers. And San Diego County's policy prohibits the sale of flavored tobacco products broadly, with the exception of hookah. They also paused e-cigarette sales for 1 year. The plaintiffs in that case also brought express preemption under the Tobacco Control Act and implied preemption claims. One interesting note is that they targeted the hookah exemption in particular, at least the retailers did, and they argued that it was an arbitrary exemption and that the definition of shisha in particular created a tobacco product standard because it described shisha as a product that traditionally includes ingredients like molasses, honey, fruit pulp, or dried fruits. So this claim may not succeed, but it does suggest that there may be some increased litigation risk for jurisdictions that are moving forward with exemptions like the one that San Diego County used. So this is also set for a hearing on December 10th before the same judge. The cases have been combined to that judge with the SB 793 case. And so they're going to be hearing both motions to dismiss and motions for a preliminary injunction. Briefly, we'll touch on the PALMDALE case. PALMDALE had a policy prohibiting the sale of all flavored e-cigarettes, and the California Smoke and Vape Association challenged that. That got transferred to a judge that was also handling the LA County cases. And at that point, the plaintiffs voluntarily dismissed the case. So this one is not pending any longer. And then Palo Alto has a case that is not like the others. This is not a preemption case, but it's worth discussing. So Palo Alto, their ordinance restricts the sale of flavored tobacco products and all e-cigarettes. They originally had a hardship exemption, but that was eliminated. And so they've been sued by retailers in the city of Palo Alto. And the main claim that they're bringing is a Fifth Amendment takings claim, which is a question of whether this was a valid use of Palo Alto's police powers or whether they needed to provide just compensation for a taking. And we have a publication that is coming out soon about why takings claims are not likely to be successful. But briefly, the way courts have looked at these in the past is to focus on the value of the entire property when making a takings analysis. So, for example, some courts have looked to whether there is more than a 50% reduction in the value of the property. And they've also looked to different uses that you might be able to put the property to. So it may not be enough that if a store only sells tobacco products, they're prohibited from selling all or certain tobacco products. If the store could now turn around and sell other products or other less harmful products that courts have found may not be a taking. So these claims have not been successful in other jurisdictions, and we believe there is not a high likelihood of success as well. They also are bringing claims under the California Constitution as a liberty protection and under equal protection, arguing that they are a class of people who've been denied rights that others in similar circumstances enjoy. The court has denied the plaintiff's summary judgment motion, but the case is still pending. And that brings us to the last cases we'll discuss in California, which are the LA County cases, and these are the ones that have actually reached a decision. So the County of Los Angeles was sued by both retailers and manufacturers, and they have a comprehensive policy that prohibits sale of all flavored tobacco products in the county. The challenges, again, were based on federal preemption, on an express and implied preemption. The tobacco retailers also brought a vagueness claim under the 14th Amendment due process. And these cases were both dismissed in August with prejudice, meaning they can't bring them again. So we'll just walk through each of the claims that they brought briefly. So on the express preemption claim, similarly to the cases that Jima described earlier, they were arguing that the county ordinance was creating a tobacco product standard because anytime they argued you are regulating its flavors, you're necessarily regulating ingredients that are used in those products. But the court disagreed and cited the previous decisions that Jima mentioned from the First and Second Circuits and from the Chicago case. And they concluded that LA County was not telling the manufacturers how to make the products or what ingredients to include, but rather that they were banning the sale of a final product. For example, they pointed out that you could look to how a product is marketed or sold, such as the packaging, which doesn't require you to look at the ingredients at all. So one of the key quotes from the case was, "A prohibition on the sale of a distinct product is simply not a product standard." On the implied preemption claim, which was an obstacle preemption claim, they first claimed that the Congress, in creating the Tobacco Control Act, wanted to create a uniform manufacturing standard. And the court rejected that for similar reasons as to why they rejected the express preemption claim, saying this is not creating a manufacturing standard. The second conflict preemption component was that they argued that FDA and Congress had purposely exempted menthol, and so therefore there would be a conflict if a local government was restricting menthol. And the court rejected this claim as well because they found that the Tobacco Control Act allows jurisdictions to go further than the federal standards so long as there's no express preemption, such as having a tobacco product standard. And since there was no express preemption, they were allowed to go further and regulate menthol. On the vagueness claim, which was a question over the interpretation of how to determine if a product was flavored, the court found that any ordinary layperson could determine whether something has a taste or an aroma. So the approach to determining flavor was appropriate, and and they dismissed that claim as well. R.J. Reynolds, the manufacturer plaintiffs, have appealed to the Ninth Circuit, and so that case is moving forward on appeal, but so far has not been scheduled. And with that, I will turn it back to Jima.
Thanks, Jamie. I just wanted to clarify, or I guess ask you, what should local California jurisdictions that are looking to adopt flavor ordinances be thinking as far as risks involved with litigation?
Yeah, thanks for the great question, Jima. So there are 100 jurisdictions right now in California that have passed local flavor ordinances, and we just ran through the ones that have been sued. So The vast majority of them have not been sued, and so far the focus has been on the larger jurisdictions that probably have a bigger impact on sales. We've had the LA County decision, which is consistent with the other decisions that have been made in the past in upholding the flavored tobacco bans and finding them not to be preempted. So at this point, there's no reason for jurisdictions to use a litigation risk as a concern, I think, for not moving forward with a local flavor ordinance. And in addition, we have seen under the SB 793 law that they explicitly did not preempt local jurisdictions. So those 100 jurisdictions are all able to move forward with their policies, even if they're stronger than the state policy. And they're also able to pass policies stronger than SB 793 under the state law.
Awesome. Thank you so much, Jamie. And now we'll go ahead and pass it on to Kira.
I'm going to talk a little bit about the cases that have been filed in Minnesota and then Pennsylvania. I'm sure a lot of folks are familiar with the EDINA case in particular, which was a case filed by RJ Reynolds, which, as Jamie just mentioned, has been really litigious in California. And then another case that was filed a little more than a year ago now against the city of Arden Hills, also in Minnesota. Both of these cases raise the same kinds of preemption claims that Jamie just outlined. And I'm going to go through each of them in a little bit more detail. So the first one, RJ Reynolds v. the city of Edina, was filed against a comprehensive flavor policy that eliminates the sale of all flavored tobacco products. As Jamie just outlined, there were express and implied preemption claims brought against the ordinance, arguing that Edina's ordinance imposes a product standard, which is pretty much identical to the claims that were raised in the LA case. Like the LA case, this one has already been heard in front of the district court, and the district court has issued an opinion. And this one is really important because it's distinguishable from pretty much every other court that has viewed any, or that has considered any of these restrictions. And that's because the Minnesota court basically said, okay, there's no, the distinction between a sales restriction and a manufacturing and additive restriction is kind of a false distinction. The court was not persuaded by any of the other reasoning and instead said, well, the Tobacco Control Act contains a product standard that restricts the sale of characterizing flavors, of cigarettes with characterizing flavors, although of course it exempted menthol, but it called that a product standard. So this seems like it's a product standard. And the Tobacco Control Act includes the authority to restrict the sale and distribution of a tobacco product to the extent it's necessary for the protection of public health. So essentially, the court said, well, this is a product standard. However, if you look at the rest of the act, there are two other really important provisions. So there's a preemption provision, but then there's also a preservation clause and a savings clause. So the court looked at the savings clause and said, okay, well, basically, local jurisdictions have the authority to restrict the sale and distribution of a tobacco product. And so essentially, the idea is that it's very, very different from the reasoning in all the other cases, but the outcome was essentially the same. So the tobacco product standard is preempted, but the local jurisdiction is saved. The restriction is saved just based on the plain language of the Tobacco Control Act. Maybe not surprisingly, that case has also been appealed to the Court of Appeals. This, because it's in Minnesota, was appealed to the 8th Circuit Court of Appeals. And as many of you probably know who like to follow Supreme Court issues, it's kind of hard to get the US Supreme Court to review cases unless there's something called a circuit split, which is when one circuit goes one way on a question that another circuit has considered and gone a different way. So considering there are two potential appeals going in front of the 9th and the 8th Circuit, which are traditionally kind of different in the way that they view issues, it's likely that the industry is being calculating in the way that it's challenging these restrictions. And as Jamie mentioned, the vast majority of restrictions are not being challenged, but these two cases really present important questions of law when it comes to what is preempted under the Tobacco Control Act. So that's now being appealed. The briefing is ongoing, and we'll be watching carefully to see what happens in that case. The second case in Minnesota that I mentioned was the City of Arden Hills case. This one also eliminates the sale of all flavored tobacco products. It was filed in Minnesota State Court, which is different than the EDINA case, which was filed in federal court. The retailer in this case made a lot of claims, sort of took the kitchen sink approach, but also argued preemption along with equal protection, vagueness, takings, which is what Jamie just discussed, and more. The city has agreed to an injunction, which means that the policy is not in effect while the litigation is ongoing. And as far as we know, there's been a settlement conference scheduled for that case in May. So we're waiting to see what happens in that case, watching it. This also kind of just highlights that not every single case is going to be litigated for years and years. There are outcomes that don't necessarily result in a decision, similar to the dismissal that Jamie mentioned before too. So the city of Philadelphia has a flavor restriction that has also been challenged in two different lawsuits. The first one is the Cigar Association of America, and the second one was the Asian American Licensed Beverage Association, along with R.J. Reynolds Vapor. So again, R.J. Reynolds' presence in this litigation. And these cases are different because these cases raise what are called state law preemption claims. So Jamie had that chart of what all the different types of preemption are. And we've been talking so far about the Tobacco Control Act, specifically preventing local jurisdictions, or arguably preventing local jurisdictions from enacting flavor policies. These cases talk about state law preemption. So the idea being there's some sort of state law that exists that restricts a locality from imposing these kinds of standards or enacting these kinds of restrictions. Both of these are pending. The first one, the Cigar Association of America v. City of Philadelphia. The Cigar Association is also another group that's been filing numbers of lawsuits, most notably against FDA, and they have some ongoing cases that are challenging the FDA's deeming rule and pre-market review. But essentially in this case, the ordinance in Philadelphia prohibits the sale of all flavored tobacco products except for in adult-only retailers. So the challenge that was brought was based on state preemption though. So state law prohibits Philadelphia from enacting this kind of restriction. It also brought due process and vagueness claims. There was an oral argument on a preliminary injunction motion, which was held about a month ago now. So that's being briefed, and we're going to be watching carefully to see what happens. I should also mention that that case was filed in state court, and then it was removed into federal court. So that's now in federal court. And then the last case, the Asian American Beverage Licensed Beverage Association of Philadelphia v. the City of Philadelphia. As I mentioned, RJR Vapor is also a plaintiff in this case. So challenging the same ordinance, Philadelphia ordinance, and this one is also based on two separate state preemption claims. So one is saying the state fiscal code prohibits Philadelphia's ordinance, and the other one is just based on a local government code restriction. So the challengers in this case also requested an injunction. That's a really common, we've seen that in nearly every single case where the plaintiffs are asking the court to prevent the implementation or delay the implementation of the ordinance until the lawsuit is resolved. So that's a pretty brief outline of the cases that are going on in both Minnesota and Philadelphia. And I'm going to turn it back to Jima.
Thanks, Kira. So did the Minnesota court's decision reference the LA County case or earlier cases in its opinion at all?
Yeah, it did. The district court in the Minnesota, the EDINA case, did specifically call out the reasoning in the LA case and in the New York case and some of the cases that you mentioned earlier, and said, these other courts have found that these flavored restrictions are not product standards and they're not preempted, but they haven't really gone into a very compelling analysis of why that is. And so the court in Minnesota just kind of rejected the reasoning of these previous decisions and went through its own analysis. And as I mentioned, the outcome was the same. It upheld the restriction, but it is just notable because it explicitly distinguished what it was doing from the earlier cases.
Okay. And then can you talk a little bit more about the state preemption claims and just, is state preemption a concern in places other than Pennsylvania? Or should other cities, such, like how Philadelphia was, should they be concerned about state preemption?
Well, state preemption is definitely one thing that we're seeing the industry get behind. It's beneficial if the industry can just lobby for some sort of preemptive law that prohibits these types of things happening at the local level, which is why we need to be really vigilant for these types of bills being introduced and trying to prohibit localities from introducing these kinds of restrictions. So it's definitely something. It's going to be different in every situation, and every state is going to have something a little bit different, but it's important to just be very aware of. And there's no question that when these laws exist, the industry is going to be aware of them and probably going to try to figure out some way of using them if they can.
For sure, thank you. And then lastly, so basically what you and Jamie have kind of discussed and told us is that the decisions that have come down thus far have been in favor of public health, right? And that favoring the Tobacco Control Act, right?
Yeah. As Jamie mentioned, the vast majority of these restrictions are not being challenged. And every single case that has been heard so far, and there's been an opinion issued in, has been in favor of public health. They've upheld these ordinances. And so it's really important to keep that in mind. And I should also just add on the preemption point too, there are, states where it's pretty clear that localities do have the authority to do these things. So it's just important to be aware of the laws that apply in your state, and keep in mind that the vast majority of these either haven't been challenged or they have been challenged and then have been upheld, or actually all of them have been upheld. So yeah.
All right, thank you so much, Kira. And now we will turn it over to Natasha Phelps to wrap things up and give us some more information.
Hello, everyone. My name is Natasha Phelps. I'm a lead senior staff attorney at the Public Health Law Center, and very happy to be talking about this today. And really, my role is to address the confusion and the chilling effect that these flavored tobacco regulations now facing litigation have on communities that are interested in working on flavored tobacco regulation or are currently working on flavored tobacco regulation. I want to ground us in some context and maybe go over some key messages or takeaways that you could use for the communities that you're working with that we think would be helpful. So I have 5 key takeaways that I'd like to go over with you today. The first takeaway is, a really good transition from Jamie and Kira's presentation, right? So takeaway number 1, local action on flavored tobacco sales is legal. That's a really important point to drive home, because here's what we know. Most importantly, all cases that have been resolved to date, as Kira just said, have been in favor of public health. All court cases have told us that local governments can legally pass flavored tobacco sales regulations, including full flavor bans that prohibit the sale of all flavored tobacco products everywhere within the jurisdiction. Full stop. That must be communicated to communities. This is something that they need to hear. Yes, there's ongoing litigation. Yes, the tobacco industry is litigious, but in all of the cases that have been decided so far, with the most recent decision being on the full ban in EDINA, the court has said that they are legal. So there's significant precedent and evidence to lean on. And so providing this message to communities hopefully helps to temper the fears of the threat of litigation by the tobacco industry to essentially preempt local communities with this chilling scare tactic. And it's true. The other thing that we know is that the tobacco industry is concerned about this public health success in court and this movement to prohibit the sale of flavored tobacco. And why? Why are they concerned? Well, we know that flavored tobacco is the foundation of their business. It's how they hook kids and keep adults smoking. It's how they replenish their dying consumer base. Research demonstrates that flavored tobacco products are especially attractive to youth, increasing initiation among all populations by masking the harsh taste of tobacco and nicotine. Research also suggests that the people who smoke long term start most with flavored tobacco products. And so the tobacco industry was the first to know this and push their flavored products for immense profit for a long time. They know that they have to stop this effort to prohibit the sale of flavored tobacco products, or they risk losing significant profits, perhaps even seeing a collapse in the entire industry. And so you can measure the tobacco industry's prioritization of stopping flavored tobacco regulation by the litigation, their threats of litigation, and their roundabout ways of trying to stop local policy work, like paying Black leaders to show up and appropriate the messages that are very concerning to certain communities, like police brutality, or paying for a referendum in San Francisco to overturn the first flavor ban in a major U.S. city. So on the screen to your right is a letter written in 2016 by the law firm Jones Day, threatening a lawsuit against a local government for its flavored tobacco sales regulation. The letter was sent overnight and by fax, so you just know how serious they are. Or in other words, to scare the jurisdiction from protecting the health of its residents. And for those of you who don't know, Jones Day is an international US-based law firm that represents R.J. Reynolds in general, and in the litigation that Kira and Jamie went over. They're not having a great week in the news. And if you don't know what I'm talking about, you just Google their name and a bunch of articles will pop up. But by taking the time to understand and educate communities on this huge investment in litigation that the tobacco industry has made with regard to flavored tobacco, it will also help us understand how to respond to their attacks and how to inspire communities to continue to work on flavored tobacco regulation. So let's take a look at how deep the industry's influence goes, how they have taken full advantage of the marginalization, discrimination, and inequity facing communities in the United States in order to make a profit, regardless of the cost to others. So how can we use this information to understand how we can prevent the harm and death caused by commercial tobacco products? Okay, so my takeaway number 2 is because now is the time to continue to work on flavored tobacco. So it's legal, and now is the time to keep going, to go further, to advance public health and to end the devastation that commercial tobacco products have caused. The tobacco industry's predation of marginalized communities is deep and long-standing. I'm sick of it. I know many communities are. I know probably almost all of you are, if not all of you are. And now is the time to say enough is enough. The tobacco industry has, for example, invested in the permeation of Black culture early on and has made immense wealth ever since. It's gone on so long that communities consider specific tobacco products like menthol-flavored cigarettes to be a part of their culture. From spit tobacco in rural areas, to the menthol cigarettes, for example. I want to provide a real-world example of the devastation they cause, not only to remind us why it's important to defend the public from their schemes, but also remind us what the communities that we work with are seeing and experiencing, because the tobacco industry's tactics are effective. And so we need to bring the community on board, get that community buy-in, and do this type of education on their permeation and appropriation of culture. So on the far left of your screen is a photo of the great Jackie Robinson, a remarkable athlete and activist, someone I deeply admire, as did many people of his time. As Jackie Robinson rose in popularity, the tobacco industry began targeting Black consumer markets, primarily through print advertisements in Black-led publications. At a time when virtually no Black athletes had any type of endorsement, Chesterfield used Jackie Robinson himself on an ad. So not only were athletes like Jackie Robinson and later Willie Mays, who's pictured in the center of your screen, as an in to the Black consumer market, they were particularly desirable endorsers for cigarettes because their status as athletes implied that the products were healthy and that the cigarette manufacturers were progressive in having Black endorsement agents. So as if the tobacco industry admired the athleticism of Jackie Robinson or Willie Mays or cared about Black health. In fact, it's the opposite. This is when they started infiltrating the Black community with their poison, causing death and destruction along the way. One tragic casualty of the tobacco industry's plight was my grandmother, picture on the right, Mary Phelps. She smoked Chesterfields for decades and eventually passed on in the 1980s, just a bit before I was born, and I never got to meet her. And so, as Jima mentioned, the tobacco industry has infiltrated many aspects of marginalized communities, especially Black culture, with flavored tobacco ads, from cheap flavored cigars to menthol flavored cigarettes. And there are examples of their infiltration in other and intersecting marginalized communities, including the LGBTQ+ and Indigenous communities. There's just an overwhelming amount of examples of the industry targeting marginalized communities with their flavored tobacco products. And so it's really important that we lift the veil of the tobacco industry as a predator that uses candy, mint, and other sweet or cooling flavors to lure kids everywhere, especially near youth-oriented facilities. Like, for example, the picture of menthol ad across the street from a public elementary school in Baltimore. Labeling the tobacco industry's litigation and other offensive attacks against communities that are working to protect public health, young and old, from the health harms of flavored tobacco is a clear example of injustice. They do not want communities to advance health equity or equity in general. In fact, they benefit from a lack of social, political, and economic power. They benefit when people get hooked on their products, use it throughout their life, and perish as a result. So you may be interested in doing community building and education around this messaging in order to combat the industry's further appropriation of very real issues, like I said, of police brutality, of economic hardship within marginalized communities. So come back to this message as much as you need to. This messaging is connected to the overall conversation that's happening right now about justice and equity in the world, which is why I'm saying that the time is now, that the message should be, now is not the time to pause or stop. We hope that communities feel encouraged to continue or start work on flavored tobacco products because of the supportive case law that we discussed today. And as I've said, enough is enough. Now is a time to push for policy that advances public health and equity, which includes prohibiting the sale of flavored tobacco products. And this is especially true right now. It's not lost on me, and I'm sure a lot of you, that R.J. Reynolds first sued a jurisdiction for their full flavor ban during a time where a global pandemic was depleting resources and human capacity of communities across the country. The fact that the industry is challenging these proven effective measures to protect public health when a respiratory virus that is exacerbated by commercial tobacco use and hitting communities that are Black, Indigenous, and people of color hardest is really saying something. So this year, we have seen major movement and discussion on health disparities and trauma, violence, oppression facing oppressed communities because of COVID-19, the murder of George Floyd, and other tragedies. Communities across the country are passing racism as a public health emergency action items. People are seeing the environmental impact of commercial tobacco products. So now is the time to keep going, not despite litigation, but because the litigation supports it, to push for equitable, evidence-based, preventative commercial tobacco laws and policies that support healthy, resilient communities. And that includes prohibiting the sale of flavored tobacco products. Moving on to message number 3. The next takeaway is, despite litigation, state and local action is necessary to protect public health because the federal government is still not doing so. So the FDA, despite having the authority to prohibit the sale or prohibit flavors in tobacco products, has not prohibited menthol in cigarettes and flavors and other addictive, youth-friendly tobacco products. Our friends at the African American Tobacco Control Leadership Council and the Action on Smoking and Health recently brought a lawsuit against the FDA about several months ago, seeking to compel the FDA to fulfill its mandate to take action on the FDA's own conclusions that it would benefit the public health to add menthol to the list of prohibited characterizing flavors and therefore ban it from sale. But we can't rely on this litigation to solve the problem. This litigation is ongoing and will take time to resolve. And in the meantime, especially with the support of the litigation that we have summarized today, it's up to states and local governments to do what the federal government has not done in order to save lives. The fourth takeaway is really simple. It's just that there's an abundance of evidence to support the restriction and complete prohibition on the sale of flavored tobacco products. We have a lot of information on our website, which I'll refer to later, but the main thing to think about is the fact that these types of evaluations of flavored tobacco sales restrictions are happening right now. We're seeing the results and the effectiveness of these types of sale regulations. So, when it comes to messaging, relying on the fact that this is an effective evidence-based policy option is really important. And then my last takeaway is about the people. For decades, individuals have tried to hold the tobacco industry responsible in court for the death and disease that they cause with their products. And most have really failed. And it's no small effort to bring a lawsuit against the scorched earth litigation strategy holding tobacco industry. So on your screen are photos of 3 people who were targeted and deceived by the tobacco industry, turned to litigation for justice, and were successful in that litigation. So on the far left is a photo of a young girl smiling. Her name is Marie Evans, and she was born in 1947 in Boston's Orchard Park housing project. And she's about 10 in this photo. At the time this picture was taken, she had been receiving free cigarettes for about a year from Lorillard Tobacco Company that set up shop in her neighborhood as a part of strategy to market Newport, a brand of menthol-flavored cigarettes, to children. And they particularly targeted low-income Black children like Miss Evans. At the age of 54, Miss Evans received the same diagnosis as her father, terminal lung cancer. Miss Evans then sued Lorillard, the original manufacturer of Newport, and she died 8 years before the lawsuit was won by her son. So Lorillard did appeal that decision, and the party settled for $79 million. But the fact of the matter is that it was a long process, and there's no justice for the loss of a human life. The gentleman pictured in the center, Lucian Evans England, and the young woman pictured on the right, Patrice Brown, filed suit also against Lorillard, and then came to R.J. Reynolds in the U.S. Virgin Islands in 2010. In 1960s, a 10-year-old Lucian in the center visited New York with his mother and became another intended target of Lorillard's nationwide marketing campaign. He found and took free samples of Newport cigarettes left on the doorknobs of a Bronx housing project unit that he and his mother were living in. And around that same time, a 16-year-old Miss Brown, pictured on the right, was attending boarding school in Florida when she started smoking Newport cigarettes. After seeing advertisements associating the cigarettes with a refreshing mint taste and the clear, pure water of the Caribbean. The exposure of marketing and access to products caused Mr. England and Miss Brown to initiate addictions at a young age that ultimately caused their premature deaths. Mr. England died of larynx cancer and tobacco-related bladder cancer. Miss Brown died from lung cancer. Before their deaths, each plaintiff filed a lawsuit against Lorillard for claims similar to those raised by Miss Evans. And in another landmark decision, the families of Mr. England and Miss Brown were awarded $113 million by U.S. Virgin Island juries. All 3 cases ended in the death of the plaintiffs after a life of suffering from tobacco-related health ailments. But before the case was closed, they didn't receive the justice that they deserved. These 3 humans died. They're gone. There's no amount of money that can bring them back. Their families suffered. Prohibiting the sale of flavored tobacco products can prevent these deaths from happening in the first place. And litigation is not fun, and it takes a long time. So it's a win for them to have won against the tobacco industry, but it also is a huge cost and emotional drain. And last but not least, more people to consider. The flavored tobacco regulation movement grew from the tireless advocacy of the folks pictured on the screen to the left: Dr. Philip Gardner, Carol Magruder, Dr. Valerie Yerger, and Delmonte Jefferson. For more than a decade, these 4 have made it their mission to help the country, the public health community, and the commercial tobacco world understand the menace of menthol and other flavors in tobacco products. They have shown that true engagement with communities is necessary in order to get this work done. And the communities have showed up. Communities are telling decision makers that they just want and deserve healthy, resilient communities. They want equity in order to reach equality. Perhaps some communities don't quite understand yet how flavored tobacco falls under that umbrella of justice and equity, but there is a huge opportunity here to join that momentum and gain community buy-in. The work has been done on solid ground, and the litigation supports that work. So overall, hopefully the information we've provided to you today can help you work with communities to feel that they're on solid ground to regulate flavored tobacco sales, not just despite the litigation, but because of the litigation. The litigation is supportive of local flavored tobacco sales restrictions, so that communities feel that they can troubleshoot the industry's predatory tactics, that they can be successful at advancing public health and equity through flavored tobacco sales bans. The law is in public health's favor. So here we're just troubleshooting. We're troubleshooting on the train track of public health. If you would like more information on the litigation, we do have a litigation tracker on our website that's going to contain filings. We're hopefully going to continue to update and include filings and summaries of the litigation. And then we do have several publications on our website summarizing the issues, the legal issues surrounding flavored tobacco products. And if you are interested in being involved in any of the flavored tobacco litigation that was mentioned, please contact the director of our commercial tobacco program, Joelle Lester, and her email is provided here, joelle.lester@mitchellhamlin.edu. Turning it back to you, Jima. Thank you.
Thank you so much, Natasha. So at this time, we will be doing a little bit of Q&A. We are running a little low on time, but I do have a quick question here that has been sent, and I will go ahead and provide that. So we have a question that asks, have free samples of flavored tobacco been given in a campaign style to targeted neighborhoods in a similar way that cigarettes were years ago? Have we seen any evidence of that, or vapes being handed out in marginalized communities?
I can take that if that's all right with you, Jamie and Kira. I think there are a lot of examples of new products that have been pushed to specific marginalized communities, but I think a really good example of that is the Juul's permeation or attempted permeation of reservations, indigenous communities across the United States, approaching tribes to offer free products, free Juul products, free starter kits, that include flavored tobacco like mango and menthol flavored Juul products, in order for them to understand how they can use their products to market themselves as a cessation device. And certainly there was a lot of responsiveness by indigenous leaders that work on commercial tobacco, that work on public health, and they did a fabulous job at working with and talking to the tribes about the predatory nature of the tobacco industry. And I think that it's something that we need to continue to be aware of, so that companies like Juul aren't able to get away with something like that. And so I think that's a really good example of a modern version of what happened with all the private litigants that I have mentioned in my section.
Thank you so much again. And with that, we are going to go ahead and wrap things up. Or if there are any last minute dying questions, please feel free to ask, and we can also follow up with you after our presentation. And we do want to thank everyone for coming today. We hope we have been very clear and intentional with the information provided to you all. Please remember to fill out your evaluation surveys. They really mean a lot. I don't see any other questions coming in, so thank you, everybody.